Hello, wonderful people. How are you? How is life? Hope you're good and hope you're fine. Welcome to another session, and I hope you're good. I hope you're fine, and I hope you're going to learn something today. For my returning subscribers, thank you. Thank you so much. I'm very grateful. For those who are watching me for the first time, this is Lawyers Info Hub. Is a platform where I reach out to lawyers. It's a platform where I teach law. I share experiences. I talk about legal concepts. The aim is to help the legal education to move to the next level. I'm glad you're here. So today we're looking at how to apply for virtual hearing. Application for virtual hearing. What to do with the pandemic and the challenges that comes with the absence of witnesses in the jurisdiction of the court, or instances where witnesses are not available because they live in another country, and we had to before now we have to keep seeking adjournments to enable them come back. um, with the practice directions have been made by various courts on virtual hearing, we can utilize this opportunity to fast track the time spent in court. You it is not a new thing with what the world is experiencing. That there are situations that make people not to be able to move around, and in that instance, we can't continue to wait for that person's availability. Why time is of the essence. So, how do you apply for virtual hearing procedure or proceedings in your matter where the witnesses are not available, or you choose to? Sometimes they are available, but out of circumstances, they might not be in court or will not be able to come down to the court in that on that day, or for some other reason. So you can utilize the virtual platform or the virtual hearing procedure, to move your on with your matter. Now, I must commend judges who have have utilized are still utilizing, you know, virtual videos and platforms virtual avenues to see that their matters are going on. It takes a lot of courage. It takes a lot of time. It takes a lot of the internet. Despite the internet challenges, I must say I know of a judge whose um, daily sittings, daily sittings are live. So once you choose virtual options, you meet the registrar, put that if you are going to tender documents, you submit your documents ahead of time. All parties can come together and harmonize documents, the ones they accept and the ones they are rejection, and all of that, and harmonize same and submit ahead of time. So people love that because you can choose to be in the comfort of your office and attend proceedings. Trials are taken on online, and I'm always amazed whenever I'm in that court. So other judges are also doing good. They're trying, why some are still hesitant in granting this application for virtual hearing because of logistic issues. And for some courts, you need to liaise with the ICT unit of the judiciary arm where you are, the court where you are located. You liaise with them in terms of the projector, lot of internet connection, and all of that. You know, it's not it's important that as a lawyer, even for our judges to be to be abreast with what the technological drive, the technological uh, um, um, trend, because some of them, because of the challenges or the technicality involved, they choose to not to grant such application. But if you're in the situation that you need this virtual hearing, and because you want your matter to go on, and you feel, why would my client come all the way from the United States of America where we can conduct virtual hearing? So you make an application by way of a motion and notice. Then you bring it. There are some jurisdictions that have amended their rules to include virtual hearing. whereby some jurisdiction there are still practice directions in this life. So you make reference to the practice direction. If it's already in your rules, you make reference to your rules, and you bring it by way of emotion and notice. You make application for leave to grant, for the court to grant you leave, to conduct maybe your trial by virtual means. You have to state the means. Is it by um, is it a Zoom thing? Is it Google Meet? Just you have to state the options you want to use on your motion paper. I state the grounds for which you're bringing your application is predicated upon. Is maybe the claimant or the witness is not available, the head ground is out of the country. Just you have to state the grounds, because sometimes the judges want to look at, why do you want us to go through this route? Can the person come to court? What is preventing the person from coming to court? That is our normal orthodox way. But you have to put in grounds, convincing grounds, to make the court understand the reason why you want to opt that this route of the virtual you know mint. So after that, you put in your affidavit, also expatiate why and the circumstances you have found yourself that will make you rely on the virtual platform for your matter to go on. So you started then, you put in your um written address. I know there are plethora of cases where the virtual uh the virtual route in terms of conduction of proceedings have happened, and I think so check them up. And the fact that it's convenient, the fact that even with what the world is experiencing, the congestion of court, these are facilities enabling you, present your case. So the fact that um, there are barriers or interferences, objection or obstruction that is stopping the availability of your witness, you put them out there. There are a lot of cases on it. Then you make your argument, and you find it on the day of your argument of your motion, hearing of your motion, you move your motion. Even though many judges will want to ask questions, interrogate you, why do you want to do this? I can give a 3 months time adjournment to enable the witness come. You can stand your ground, make your application, and note that you have to liaise with the ICT. Many judges do not the facility, so you have to undertake. Either sometimes many lawyers bring their own projector where there is no projector in the court, or where there's a projector, you have to liaise with the ICT unit, because sometimes you can do them a letter depending on the procedure in your jurisdiction. You do them a letter letting them know the date of your matter. Then you meet them ahead of time. You discuss availability of internet. Do you have internet? You need to, whatever it is you need to do with them to ensure that your procedure goes on well. And also the fact that the witness who will testify, or the procedure that will happen, both parties have a stable internet connection, and they can assess. You can't be applying for a witness to testify where the witness cannot even connect the platform. So these are things you need to sort out so it to be hit free. Because I've seen in a situation where the court was frustrated because of the internet hitches and the glitches that happen. When there's an internet glitch, they're frustrated, and the witness was not able to connect. Do this, you mute, unmute yourself, all those things. So if you need to do like a pre-trial with your witness, or before then familiarize yourself with the modalities of the avenue or the platform you want to use, so that it will be seamless that day. And you also have the fact that you have to alliance with the ICT unit. Some other people jurisdiction where there is no ICT unit, you can bring your IT person in court to help you set up, facilitate. Just like when you want to maybe watch a video evidence, many courts do not have that facility. So lawyers, facilitate that, bring their maybe TVs or the projector, or facilitate the fact that that video, which is essential to your case or to your matter, is is played. So that is also how you facilitate to ensure that it is hit free. A lot of courts are granting it, and just take the bold step. And many other courts who already have embraced the technological era we are in, you know, allows counsel to choose, will you want a virtual? And most courts now deliver their judgments ruling virtually. So even as a lawyer, as a student, you're not used to operating these devices or connecting. You need to go learn, because we're in that era where these things are inevitable and now becoming a necessity. So just do your application like a motion, state your grounds, affidavit, written address, support it with cases, and I know that if it will be granted, unless there are estimated circumstances that the court will let you know that these are the reasons why I cannot grant this application, or these are my challenges. So, in whichever way it is, if it's something if it's something you will accept, fine. If it's not something you can write to the chief judge in your jurisdiction for the matter to be assigned to a judge who is tech savvy. So these are things you can do to help your case rather than wait 6 months time adjournments and all of that. You can see the comfort of, and I've seen matters that have been concluded seamlessly through these avenues, and life moved on. So you have to be creative. We have to blend with the trend in terms of technology. And I know that sooner or later, we might be dispensing with the traditional court sitting and a physical court sitting because of the way things are happening. So, friends, I hope you've learned something today, and I know you'll try it out where you need to do so. And also share this video. Let me see your comments. Please drop it on the comment section, and share this video. Thank you for hitting that subscribe button. Thank you for always stopping by to know what is new on this channel. I'm very grateful. I appreciate you. I'm very, 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 very grateful. And thank you for supporting this vision of mine as we push to help to grow the legal education. Thank you.